welcome to Dolly Talk. How is everybody doing today? All right, we have a. Sorry, guys, all my settings are all different today again. Someone keeps changing them. All right, so we are doing the closing. We were trying to get through it yesterday, thinking there'd be a verdict yesterday, but that did not happen. Um, so they came back today. We will get to that. No spoilers, please. But first, let's say hi to a few people. Tracy, how you doing? Revette's here. Louise and Scott. Wow. I'm not a boy, so I can spoil. No. Jim is here. Scott. Okay. Said hi to everybody. Oh, Patrick. Nice for you to join. The jury was 50-50 men, women, and mostly white with an Asian Indian person. Interesting. And yeah, I think I posted my email address if your friend is interested in an interview or anything, or just has thoughts, that'd be cool. And I also put the playlist in if you haven't seen the day 1 and day 2. It was an interesting trial. Kind of one of those where, yeah, you knew what he did was, in my opinion, was wrong, but I can feel like the guards were kind of a problem as well. That's Warren County. Donald's here. Okay, so let's start closing. And then we will, after closing, we will get and see what they've gotten to in the they've gotten to a verdict or not.
Closing arguments. Ms. Tranter, because she has the burden of proof in this case, will address you both first and last, with Mr. Engel in the middle. Ms. Tranter, you may proceed.
Thank you, Your Honor.
An Engel Oreo. Hey, Mavka. Yes.
All right. Good afternoon again, ladies and gentlemen.
Ooh, look at that.
Thank you for your time. And
Now that is a fancy, fancy PowerPoint. You got the State of Ohio v. Thornton D. Thomas. They even put the case number on there. Then we got David P. Fornshell, prosecuting attorney, this whole seal and everything. That's a pretty good PowerPoint, or at least the intro. 6 out of 10, 7 out of 10.
Attention for these past couple of days. We're wrapping things up. And what I like to do in the first part of my closing, because the judge said, has already told you I get to address you twice, is we're going to go through the charges and the elements and the facts and evidence that you've heard that relates to each of those. Okay? So,
right,
as you are aware, the defendant in this matter is charged with 4 separate counts. Okay? Count 1 is felonious assault. And the language of felonious assault is that on or about.
And of course, she had to put demon in there.
Which is our date of incident in Warren County, Ohio. That's what gives this court and Judge Oda jurisdiction to hear this matter, because it happened at Warren Correctional Institution, which is in our county here. Defendant Thornton Demon Thomas did knowingly cause serious physical harm to Owen Sycamore, who is one of the corrections officers. Okay? Now, you're going to get a lot of instructions, and I don't know. I apologize because I don't know how to make that thing on the bottom go away. I don't know if that's me or.
Does she mean this?
But we'll work around it. So part of what we do in jury instructions is give you definitions, okay? And some of those definitions might not
Okay,
kind of
sweetie.
coincide or jive with
Oh
what
God,
we use in
I
our
was
normal,
giving you such
ordinary
high
day life.
praise
I'll
on
give
your
you the legal
PowerPoint title.
Okay. So, as part of felonious assault,
Honey.
you receive the definition of serious physical harm.
Oh my. No, 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 no. Okay, the only props I give you is the use of a semicolon. That's kind of impressive, but no. First of all, I don't know, maybe Nidawal can say, but how big the TV. I'll turn the cord up. Thank you. I was wondering if it was low. I don't know how big the TVs are. I will say when I went to the Lori Vallow trial, the closing PowerPoint Trina did was god awful. You put a bunch of this text on there. A lot of times the jury can't really see it. And when you just put a block of text like this, oof. Lawyers don't learn PowerPoint in law school. I know. I've been hanging around Hella too much. She does that stuff and it's kind of rubbed off on me, but that's just kind of, I don't remember it being all that big. It just looks like someone vomited text on there. At least I don't see any typos yet, but still. All right, I'll turn it up, guys. Sorry. Thank you for letting me know. Anytime volume's off, please, please, please let me know in chat.
That is any harm. It's 4 separate things can qualify as serious physical harm, right? First is any physical harm that carries a substantial risk of death. Any physical harm that involves some permanent incapacity, whether partial or total, or that involves some temporary substantial incapacity. Any physical harm that involves some permanent disfigurement, or that involves some temporary serious disfigurement. And any physical harm that involves acute pain of such duration as to result in substantial suffering, or that involves any degree of prolonged or intractable pain. That's a lot of words up there. So don't get overwhelmed in that. To meet serious physical harm, we only have to show beyond a reasonable doubt one of those. Okay, so what we want to focus on, your attention should be drawn in this particular case, is to the third one down. Any physical harm that involves some permanent disfigurement or that involves some temporary serious disfigurement. You heard testimony from Officer Sycama that he had injuries as a result of this attack. 2 things are important about his testimony. First part was he testified that he has a scar on his lip from his busted lip that he suffered. That's a permanent disfigurement. Second part of his testimony that is important is, of course, his fractured tooth. You saw the photos. He's got half a tooth missing. I would argue to you that is permanent disfigurement. No matter what he does, that tooth is never going to grow back, right? If you don't view it as a permanent disfigurement, you certainly can view it as a temporary disfigurement before he got the cap put on to look nice and neat and normal again. It certainly was a temporary disfigurement, but I argue for the purposes of this case, it is definitely a permanent disfigurement. He's going to live with that for the rest of his life. Count 2, assault. Same date, Warren County, Ohio. Same.
And Dolly, regarding audio, can't you tell the court lady to stay at an equal distance to the mic? That would be very nice. There was I forgot to tell you guys, there was a mad scramble this morning. Oh my God, Hella is up. Boy, you just missed my rant on her PowerPoint. I did not think you'd be up right now. I just had a long rant about it. The court feed, I was about ready to get it going. Donald, I was about ready to get it all set up this morning to record. And Oda's court, Teeps, and Peelers all went down. Okay, no panic. I'm sure they sometimes do that and they bring them right back up. Well, Teeps came up, but Judge Oda and Judge Peelers, in live 10 minutes, were still down. And they were down for like an hour, even when the jury got in. So I emailed the court and they told me They're working on it. Recovery Addict had someone there. He was, that person was telling the court that it was messed up, but thankfully we did get a feed in time.
Defendant did knowingly cause or attempt to cause. It's a little bit different language. First one was cause serious physical harm. This is cause or
I missed
attempt
the
to
rant,
cause
but I got a cool water.
physical harm to, again, Officer Sycamore. He's the subject of this one as well.
Thank you, Dina.
Okay. I had a, oh, I didn't have it. Okay. So count 2, and we're going to see as we go through on count 3 as well, have these additional findings. Okay. When the judge reads you and your jury instructions, you are going to hear that both sides, myself and Mr. Engel for the defendant, have stipulated to all of these elements. So these are not even going to be a discussion for you. Okay. The offense occurred in or on the grounds of the Department of Corrections and Rehabilitations. That's Warren County Correctional Institution. Victim of the offense was an employee of that Department of Rehabilitation and Correction. Obviously, we know he was a corrections officer. And the offense was committed by an incarcerated person. Mr. Thomas was incarcerated by the state of Ohio at the time. Again, those are all stipulations. You guys are not going to have to worry about those. Count 3 is the exact same language, except this time instead of Officer Sycamore, we're dealing with Officer Romine. Okay? Exact same language that the defendant did knowingly cause or attempt to cause physical harm to Officer Romine. Physical harm for this purpose, a little bit different than serious physical harm. So to prove physical harm, I have to prove to you any illness, injury, illness, or other physiological impairment, regardless of its gravity or duration. So it's a little bit of a difference in the language. Count 3, those are the furthermores from count 3. Again, all of those findings have been stipulated by both sides, so those are not additional.
I'll post it, Jim.
Strangulation, count 4. On or about July 23rd, 2024, Warren County, Ohio, the defendant did knowingly create a substantial risk of serious physical harm to Casey Romine by means of strangulation or suffocation. So here, we're not dealing with an actual creating or actually causing serious physical harm. We're dealing with creating a risk of serious physical harm. So the relevant testimony to that obviously is Casey Romine describing how the defendant not only punched him for purposes of the assault, but also put him in a headlock chokehold for upwards of 30 seconds. Now we've done the basic elements. Defense has proposed a self-defense theory in this case. So you've got kind of a two-part analysis when you're going through these. And again, I'm going to highlight some things. Judge is going to give you the full instruction at the end, but we're going to break this down because this is a step-by-step analysis, okay? So the first thing you're going to do is you have to determine the amount of force that the defendant was subjected to by the corrections officers, okay? The law states that corrections officers may use force against an inmate in these specific situations: self-defense from a physical attack, or defense of another from physical attack or threat of physical attack, prevention of an escape or apprehension of an escapee, and controlling or subduing an inmate in order to stop or prevent self-inflicted harm. So if they're cutting or harming themselves. For this particular case, I am going to submit to you that the officers were within their rights to use force against Mr. Thomas because of these two reasons. When necessary to control or subdue an inmate who refuses to obey prison policy. Okay? He was directed to sit down and let them search his cell. He disobeyed that order by getting up, pacing around, knocking the water cooler over. He disobeyed that order by repeatedly refusing to obey their commands to cuff up. You heard Officer Blythe tell you the policy is you get 3 warnings and then you get a final directive. Cuff up, no response. Cuff up, no. Cuff up, no. Final directive, cuff up, no. And then he gets OC straight. You also may consider that the officers could use force against Mr. Thomas when necessary to stop an inmate from destroying property or engaging in a riot or other disturbance. He knocked that water cooler right off. Possible destruction of prison property. Certainly created a disturbance. You can hear it hitting the floor. You heard Officer Blythe say that's the reason why he came out of the cell, is because he heard all the commotion. He certainly was committing an act that was a disturbance. These officers were well within their rights to use force against Mr. Thomas to get the situation under control. Now, let's talk about force. Reasonable force, and I've had to divide these up because there's a lot of words on them again, means force used in accordance with these following guidelines, okay? Number 1, corrections officer may use a small amount of force, as may be necessary to restrain, guide, support, or direct an inmate to apply handcuffs, waist or leg restraints in connection with accepted procedures, transport, or movement, okay? We know that they were trying to apply handcuffs to him at this particular point. We know that he was resisting. Reasonable force can be also used in this manner. Corrections officer, considering the use of force, shall evaluate the need to use force based on the circumstances as known and perceived at the time it is considered. No Monday morning quarterbacking. No, if he did this, shouldn't you have done this? This is an in-the-moment time frame that we're talking about. This is not looking back and saying, could I have done things better? This is in the instant, has to be viewed from a corrections officer experiencing it at the time. Reasonable force may be used in this instant. Corrections officer may use force only to the extent deemed necessary to control the situation. Corrections officer shall increase or decrease that level of force as resistance increases or decreases. So if a defendant is escalating, their force can escalate. De-escalating, force can de-escalate. So it's kind of a sliding scale, up and down. Last 2, a corrections officer should attempt to use only the amount of force reasonably necessary under the circumstances to control the situation and shall attempt to minimize physical injury, and force or physical harm shall not be used as punishment. Okay? You have heard testimony from all the officers involved that their force was, their reasonable force was used not as a punishment, not because defendant was bad-mouthing them, but because he was not complying with their orders and their commands.
To stop bad-mouthing them.
So if you determine that the amount of force that Mr. Thomas was subjected to was reasonable and the officers were reasonable in that application, stop. Your analysis is done.
Wait a minute.
An inmate has no legal right to resist reasonable force. Don't overcomplicate it. Self-defense argument is a no-go at that point. Your analysis stops. Defendant is guilty. Now, I submit to you that when you're back in the jury deliberation room, that's as far as you're going to need to go, because you're going to find that the force used was reasonable by Officer Sickman and Officer Romine and Officer Blythe. So your analysis should be done. However, if there's a question, which again, I submit there's not going to be, you continue your analysis, okay? If you determine that the amount of force that Mr. Thomas was subjected to was excessive, then you can consider self-defense. So if for some reason you say the force was not reasonable, you move on to step 2. Self-defense, the state must prove beyond a reasonable doubt that the defendant, when using force, did not act in self-defense. To prove the defendant's use of force was not in self-defense, I have to prove to you beyond a reasonable doubt only one of these, the following 4 things I'm going to put up there. You've got 4 options, but I only need to show you one. It's not an and, it's an or at the end of each of these statements. Number 1, defendant was at fault in creating the situation or giving rise to the use of excessive force by the corrections officers. If you find that he was at fault for creating the situation, stop. He's not entitled to self-defense. The second and third one don't really apply, but they're there as options for you, okay? Defendant did not have reasonable grounds to believe that he was in immediate danger of being subjected to excessive force, or defendant did not have an honest belief, even if mistaken, that he was in immediate danger of being subjected to excessive force. Now remember, if you're at this part of the analysis, you've already made a decision that the force was excessive and not reasonable. So we're going to move on to number 4. Defendant used unreasonable force. If you find that the defendant used unreasonable force in response to the force used by the corrections officers, he escalated the force, in other words, he didn't need to knock out Officer Sycamor's tooth, he didn't need to put Officer Romine in a 30-second chokehold, stop. He's not entitled to self-defense. I submit to you, ladies and gentlemen, that he was at fault in creating the situation, giving rise to the force. I still submit it was reasonable force. But again, if we're at this part of the analysis, we're talking about excessive. He created this situation. The officers conducted a cell search well within prison policy. They told him to sit down, let the cell be searched. He even testified, had he not argued, this would not have played out the way that this did. This is out of his own mouth. But rather than complying with the orders of the officers, he got upset. He got mad. He threw a temper tantrum. Started yelling, cursing, screaming, knocking the water cooler off, showing pre-assault indicators to the corrections officers. Let's take it a step further. He continues to create the situation because at that point, they're ordering him to cuff up and he's refusing. He could have stopped it right there. He could have said, okay, I'm gonna put my hands behind my back, cool off. And again, testified that it probably wouldn't have played out the way that it did had he complied with their orders, but he didn't. Once, twice, I think one of them testified upwards of 6 or 7 times that he was told to cuff up and he refused. He would not do it. He created the situation. He escalated the situation. This is the video that we've seen so many times. He's pacing, which they testified that was also a pre-assault indicator. And there go the water coolers.
Pacing? Yeah, wow. I mean,
This is the part where he's refusing to cuff up after multiple directives. And the OC spray is used. He created the situation. No self-defense. Again, these are the second part of the analysis. He didn't have a reasonable grounds to believe he was in immediate danger of being subjected to excessive force and did not have an honest belief, even if he was mistaken, that he was in immediate danger of being subjected to excessive force. And finally, the defendant used unreasonable force to respond to the situation. This is the other angle from, I think, the laundry room camera. Defendant fighting, punching, knocking Officer Sycamore to the ground, still being combative and not complying. Finally gets Officer Sycamore on the ground, strikes him multiple times, and ultimately gets Officer Romine in that chokehold.
Get a white shirt, get a white shirt, don't tell my man.
You heard Officer Romine's testimony yesterday that he thought he was going to die. That, ladies and gentlemen, is an escalation of the force. Self-defense does not apply. At the end of the day, ladies and gentlemen, we do believe that the evidence has shown, and the appropriate decision and only decision is that the defendant is guilty of all charges, and self-defense is not an option in this matter. Thank you.
Mr. Engel? Thank you.
State, may it please the court. It has been my honor to represent Mr. Thomas in this case.
Oh, I need to turn this.
Not because he's my friend. Not because I like him or don't like him.
Wait, not because he's your friend? What? You aren't even going to say he's your black friend? Okay. I mean, I guess he's not racist because, only a racist would say he's my black friend.
Give me anything to think one way or the other. That's not my job. But my boss is not a politician.
Okay, real quick. What's the max on these charges? So Scott said that the correction officers are not considered regular police officers. So it's not aggravating. So I believe 33 years max on all the charges if it was consecutive. But it's probably going to be less than that if convicted. No, I don't know yet. So, and no spoilers.
Or an elected official, or someone who wants to seek office. My boss
Consecutive.
is the Constitution. And if you remember, one of the first things I asked you yesterday was, why are we here? Why are we here? Why are you here? And the answer is not because we have some kind of tradition. It's not because we think it's nice, but because it's important that the people be here and that the people watch what the government and its employees do. You are the ones who get to say the government has gone too far. You are the ones who get to say this is how things should be. That's why you're here. You're here to say what is right, what is just, and more importantly, to make sure that the government does its job. And there's two ways I always think about this. The first is, I love this quote from Miles Davis. It's not the notes you play, it's the notes you don't play. Because one of the reasons you can trust the government and what it's trying to sell you is to make sure they have done the work. Make sure for example, make sure they've interviewed everybody who can be interviewed so that they know what's going on. Make sure they've gathered all the evidence that you would want to know the answer to your questions. That's what they have to do. And if they did not do that, if you think that they didn't do some of the steps that they should have, you should not be complicit with that shoddy job by signing your name to a guilty verdict. Because it's your name and your honor ultimately on the line here. And if they didn't do their job, it's perfectly fine to say, you know what? I think maybe he is guilty, but the government didn't do their job of showing me enough evidence, of doing what's supposed to be done here. And that's okay. In fact, that's more than okay. That would be the highest American ideal, would be to say, I need more. I just don't have enough. That's what you do when you make the state meet its duty of proving things beyond a reasonable doubt, making sure that you are firmly convinced of the truth of the charge. More importantly, making sure that they have convinced you firmly of the proof of the charge. Not just what you think happened, what just what you think probably happened. But do you have the evidence to support what you firmly believe happened? So here's where I think this case comes down to. The defendant acted in self-defense. He knowingly caused or attempted to cause harm to people. That's true. Absolutely true.
Tim.
No doubt
What
about
did a country music song?
But he acted in self-defense because of three things. First, the corrections officers created and provoked this situation. Second, they violated their duty to de-escalate the situation. Excessive force in gaining compliance. So let's look at what this is. I think the big picture kind of comes down to something my kids would say. One rule for me, another for thee. So think about this. Every time they're talking about inmate Thomas, they're like, he knows the rules. I say cuff up, he's supposed to say, yes, sir, cuff up. I do that. He knows what he's supposed to do. I'm going to force those rules against him to the letter of the law. If there's a blade that's out of place on that fan, I'm going to take it, or I can take it. If he doesn't have a piece of paper in the right place in his cell, too bad for him, right? We're going to strictly enforce the rules against Mr. Thomas. That's kind of what Ms. Tranter's saying when she says, hey, he can avoid this by just cuffing up. They said cuff up. He's supposed to know to do it right away. Okay, fine. But when it comes to the officers, it's more like Captain Barbosa. The rules are more like guidelines. Remember, I asked them, where does it say in these policies that you have discretion to do these things? And they're like, well, it's kind of implied. I'm kind of trained about this. I don't know. I sometimes enforce this rule. I sometimes don't. I can do these things not. When it comes to the officers, when they ask about themselves.
Is this guy a public defender? He is appointed in a while, because I know there's no public defenders per se. They're all like appointed. But I don't know if he was paid for this or he was actually appointed. I assume appointed, but I'm not sure.
They're Captain Barbosa. They're like, oh, it's more like a guideline than a rule. I don't have to follow it. But when it comes to the inmates, they're Eric Cartman. They're all respect my authority. Don't, we're going to spray you in the face.
I love
my authority. And if you don't,
he smirked. He smirked when he said, respect my authority. And then the detective just smirked. That's great.
They're all respect my authority. And if you don't, we're going to spray you in the face.
That.
So you're going to get, when you go back into the jury room, a copy of all these policies that we've been going over. And I encourage you to look at them real close. You're going to get Exhibit A. I'm sorry. Exhibit A is the cell search policy. Exhibit B is going to be the personal property policy, and so on. And so when you look at that personal property policy, you'll just see simply they're allowed to possess a reasonable amount of personal property. They're allowed to do it. And the officers kind of want you to think, well, it's kind of flexible, and maybe it's 2.4 things, this counts, this doesn't count, or whatever. But they're allowed to have it. And that's the first start, right? They're allowed to have property in there. You'll get that search policy. It says that reasonable care should be taken during the search so as not to damage or destroy cell contents. And if they take stuff, take contraband, they're supposed to generate a list. You check it. So there's the first problem, right? Where is that list? Now, they want you to believe that there was contraband. Follow their own rules. That's what I mean by doing your job. Maybe you believe this was contraband. Maybe you believe it's not. We'll talk about that in a second. That starts this whole thing. But if they followed their own rules, you wouldn't have to worry about it. They'd be able to say, here's the list, because I followed my policies. But again, one rule for them, I don't have to document everything. I don't have to create that list, even though my policy says I don't. Another rule for Mr. Thomas. When you look at that use of force policy, that should guide your consideration about whether there is excessive force here. You can take that into account. And we focused a lot of time, maybe too much time. You got frustrated with me, I'm sorry. Take it out on me later. Don't take it out on Mr. Thomas. But I think it's really important about what that policy says. There is a duty to de-escalate, and they are required to do so. Those are not choices. The word duty means you have to do it. The word required means you have to do it. And so when you think about whether there's excessive force, the first thing you should ask yourself is, did they comply with their own obligations? And if they didn't, it's excessive. That's what that means. You also have to be important to remember, should be mindful to create physical space to themselves. So think about that situation. They're in the cell, he's outside, he knocks over the water cooler. What do you see happen next? They walk up towards him. What does he do? You're still on that tape very clearly. He steps back. They keep closing that physical space. If there is a danger It's because they are making that danger apparent, again, against their policy. They're supposed to create that physical space so that they can use their de-escalation skills, which they're supposed to have, to solve this problem. And then they're allowed to bring in other people. Again, what's the cause of the situation? The suggestion is the cause of the situation is he's told to come up, he doesn't. But let's look at that world there. There's no one else around all the time in the world to make sure that things de-escalate. That's why it's excessive. Again, and we haven't even gotten to the most important thing, which is in considering whether it's excessive, you can't consider the fact that they violated their policy against creating jeopardy. People at ODRC who write these policies don't just find them buried on Mount Sinai and bring them to Ohio. They have experience in the prisons. They know what's going on. They know how these things work, and they know that guards could sometimes provoke inmates. This is not news to anybody. So they said, don't do it. You should never verbally or physically provoke someone. And they knew they were taking steps to provoke them. And then you'll get an investigations policy that says they're supposed to look into potential misconduct by the officers. And again, ask yourself, did they ever do that? You know they never did that. You didn't see one drop of evidence that anyone looked into this. In fact, you'll find out they lied about it. So here's where we start, right? The defense, CEOs create the situation. They're searching his cell. And he said he's upset about it. He thinks he's being targeted about it. And they found boots belonging to his cellmate. But again, he's just standing there quietly. Looking at his phone, writing that report. Right? You don't see someone who's angry, belligerent, upset. You see someone who's there. And I mentioned that because you heard that some of the officers in their use of force reports wrote that, hey, he was belligerent from the very beginning when he started searching the cell. He wasn't. Then, if you want to believe his testimony that he's being targeted, don't believe Mr. Thomas. Believe the words of the officers on the tape. I think this might be the most important, second most important thing that's said on this tape, on these tapes, which is they say they're looking for a shank. They find a plastic knife and joke about it. And then you listen carefully, you hear them say, there's got to be something in here. That's them admitting they are targeting him and provoking him. There's got to be something in there. They're not looking for, they didn't say there's got to be a shank in here. They didn't say it's got to be in here somewhere. There's got to be something in here because they're looking to get him in trouble. Jail.
Gotta be something.
Then they take his pillows and put them in the trash, and the defendant standing still calmly in the background. Now, you'll get to play that tape. I don't need to play it again for you. Let's talk about these pillows and these fans and their contraband, because there's a lot of argument about that. Officers claim these are all contraband. They're not supposed to have them. So let's start with that idea. Where's the proof? Where is it? They want you to believe them. They knew that this was going to bring criminal charges, and that they were going to have 12 people like you sit and listen to it. Officer knew that the next day. Trooper knew that the next day. Sorry. Trooper knew that the next day. Does he go and get that evidence? Because he knows he's going to have to present it to you. This is what we call a known unknown, meaning you don't know for sure whether these pillows are legal pillows or illegal pillows. But there was an answer to that question, right? This could have been answered so easily if the trooper had done his job and taken the evidence in the case. He could have brought them into court, showed them to you, and said they're not there. Or he could have brought them into court because he would do his job and show you that they were legal pillows. So why did they disappear? Do you draw an inference from the fact that they disappeared? That maybe Mr. Thomas was right and they were wrong and they didn't want to admit that? You could. You don't have to. It's enough for you to say, the state didn't do its job. If we don't know, it's their fault. Same thing with the fans. They don't know, it's their fault. Second, they claim, even if they're illegal, all this stuff, that we have discretion to let them keep it or not. Two things about that. And I don't say that very often. I've been doing this a long time. And I rarely say that folks lie, but that's a lie. Absolute lie. Nowhere in their policy does it say they have discretion to do that. And you don't want them to have discretion to do that. You don't want these corrections officers having that authority, which could easily be abused. Remember we talked about the Stanford prison experiment earlier, at the very beginning. We talked about how people in positions of authority could abuse that authority. Well, one of the ways they could abuse that authority is to give them discretion. You could have an officer who's completely racist and who says, you know, I'm going to take stuff from black guys and not stuff from white guys, and that's okay because I have discretion to do it. It's not right. More importantly, you don't want to let them do what they did in this case, which is use that to punish him. He's running his mouth. Okay? They don't like that. Okay? He's using some words that I won't even repeat here. Okay? But they're not the ones who are supposed to punish him for that. And what are they doing? On a hot day in July, they're taking his fans to punish him for talking. Don't believe me. They told you that's what they're doing.
Objection.
Ooh. So I'll come back to that in a second. I want to pause on two other points here. I mentioned the investigation into the way. Also want to focus on, I should have mentioned this before, serious physical harm. You have that felonious assault charge. I think you could easily look at that evidence, testimony saying a chipped tooth that got repaired and a busted lip. That's not serious physical harm. That's a night out sometimes for some folks. That's not serious physical harm. But let's pause on their testimony before we think about why I said that they told you that they did this. State's witnesses were completely not credible. I want you to compare their testimony. You heard me ask them about things in their use of force reports. And you saw how in their use of force reports, they were not completely candid. They didn't include things that were important details. That goes to their credibility. They're not telling their supervisors the whole truth. So why do you trust them to tell you the whole truth? But you can also saw there were some flat lies on the stand. One of them said, for example, a couple of them said he was pulling up his pants, and that was an indicator that he was aggressive. They'd written that in their use of force reports. That's not true. And they even admitted it's not true. But again, they're not truthful in everything they're doing in this case. But I thought the biggest example was Officer Blythe. Officer Blythe says that when Mr. Thomas was confronted about the hooch, he was belligerent. But he wasn't. He wasn't belligerent. You'll see on that tape. And you're going to get all these body camera videos to go back with you in there. And I encourage you to look at them. I'll warn you, by the way, on one of them, I think it's Officer Sycamus, That one, most of them are cut down to just the parts that are important and relevant. That one's actually 30 minutes long. You probably have to fast forward to about the 15-minute mark to get to anything that's relevant to this case. But you get the whole thing. So just a heads up on that one. When Officer Trooper Blythe, Corrections Officer Blythe says he was upset and pulled the tape. You look at that tape, you'll see he comes out with a hooch. The defendant's just standing there. And it's his cellmate who says, hey, it's mine. I take responsibility. He comes out and says, who wants to take ownership of this? Cellmate takes ownership of it. Detective Thomas is standing there. He wasn't truthful about that. You heard you heard a couple times in their use of force reports, they tried to pin the hooch on Mr. Thomas. That wasn't true either. These guys just can't tell the truth. But we said the worst thing he said was the admission that they took these things, these items from Mr. Thomas, not because they're contraband, because they'd searched these cells many times before and never taken these items. But they took them because he had the audacity to complain about it. He had the audacity to maybe start to send a kite, that communication in the prison, out to supervisors about it. Don't believe me. Listen to the Officer Blood. He denied saying this. I asked him. My only question I asked him was, did you say they want to run their mouths? Fuck it.
Hey, look, give me that one. Hey, they want to run their mouths.
He lied to you. He said he didn't say that. He looked somebody in the eye. Actually, maybe he didn't even look in the eye. He looked at me. He looked me in the eye and lied to me. So Judge Owen is going to give you some instructions in this case. He's going to tell you that the state has a duty to care for inmates. They have to treat folks humanely, appropriately. He's going to tell you that self-defense is available if there's excessive force, which will be defined as greater than reasonable force. And he's going to tell you within that instruction, quote, you must consider the conduct of the victims and decide whether their acts and words cause the defendant to believe he was about to be subjected to excessive force. In other words, it's from the defendant's perspective. What was going on, did what these officers did, the fact that they're taking his stuff for arbitrary reasons, because he's running his mouth, does that make him fear that something worse is going to come down the road? Put yourself in his position. But think about that. If you're being subjected to arbitrary actions of a state agent, are you going to trust that state agent further down the road? Now, it's true, and I'm not going to sugarcoat this. The defendant used some bad language. He knocked over the water cooler. But he was provoked to do those things by the defendant. He did not start this chain of events. Right? The prosecution wants you to think the chain of events starts when he's asked to cuff up. That's not right. The chain of events come when they start searching this cell and they don't do it appropriately. That's the beginning of the story. And you need to start at the beginning. That's the common sense, right? You don't start in the middle. You start at the beginning. And I want to emphasize the burden of proof here on self-defense. The state has the burden of proof on this. So if you're not sure who to blame, the state has not met their burden. That's when you put a not guilty verdict in. Again, you'll have this video out of this start. They say, you know what? Keep talking. I'm going to take your finger. They're provoking him. And rather than play the video, just look at what's going on while this is happening. Again, he's standing there quietly. They ask him to cuff up. He says, can I get a white shirt here? He says, they took my fans. And again, He's not acting aggressively. He never threatens anybody. His hands are down by his side. They're not in fists. This one's curled up a little bit. That one's not in the fist. You'll see the whole video there. See, he's pointing with his hands. Here's the thing. And here, this is probably the most important video. Spray. This is the moment when he's being sprayed. Where are his hands? They're behind his back. He's not a threat to anybody. His hands are behind his back. And then what does he do? If he's supposedly aggressive, if he's trying to assault people, after he's sprayed in the face, does he go after them? Does he charge at them? Try to close that distance, prevent them from doing it? Some of you had self-defense training, you know that's what you're trained to do, close that distance. He walks away. He doesn't even run away. He walks away. You'll see, he goes and walks slowly around to the other side. He's trying to wipe the spray out of his face. He's going towards that door where he says, help is coming, because he knows, having been there forever, as soon as they hit that spray, they're going to hit their button for assistance to come. He knows that a supervisor will then be coming. He knows that people he can tell the story to and talk to will come. And he'll get the help. And think about, go back to, when you look at this part of the video, I want you to go back to that excessive force, use of force policy. Talk about creating space. And think again, who's causing the problems here? The officers, if they're trying to, could have used their de-escalation skills again. It says specifically, you're supposed to kind of stop and reassess and move your force up and down depending on how things are going. He's walking away. They could have called for assistance. They could have just waited. He's not harmed anybody. He's not attacking anybody. There's no one there he could attack. He's just standing in the corner, they're away. And what do? They close that distance again. They put hands on him again. They're the ones trying to go after him again. They're the ones escalating this situation to another level. And you saw the struggle, but I want you to be really vigilant at watching this struggle here. Watch what's really going on. Is this an effort to subdue someone, or is this an effort almost like a riot from corrections officers to beat him and make him suffer for not complying with this? Are they doing what is necessary to engage the situation, or do you see folks pulling his hair, striking him in the head multiple times, not to get compliance, but to punish him? So I'll sick him back. He's hitting him again and again and again in the head, even though he told you his training is not there.
Mr. Engel, you have about 2 minutes remaining.
You see the close-ups on there. And you'll see that video where they actually, one of them comes up there and sprays him right in the eyes while he's being held down. So again, the state says this all could be avoided if he cuffed up. But Judge Oda says you must put yourself in the position to defend it first. And I told you, he did. His testimony was very credible. He acknowledged where he could have done better. The life in prison he described makes sense. And he's the only one whose testimony was consistent with all the videos. And the reality is this all could be avoided if the COs had acted in accordance with their policy. You should find him not guilty because he was not a risk to anyone. There was no effort on his part to escalate the situation, no effort on the corrections officers to de-escalate the situation. They took his property to punish him for talking. They could have called a supervisor, they didn't do it. They could have waited after spraying him in the face, they didn't do it. I could go on and on and on. You get it. You get it. This was not reasonable force. And so when you go back, I'll remind you, I'll leave you with this, a Bible passage. The Lord hears the needy and does not despise his captive people. Sir Thomas is a captive person, but he's a person. He deserves that dignity. He deserves to be treated with respect. He doesn't deserve to be provoked, to be taunted, to be treated arbitrarily. He doesn't deserve to be sprayed in the face for the audacity of asking for a supervisor to come and resolve a situation he's not. He was honest with you about what he did. He was honest with you about what he didn't do. He acted in self-defense. The state has not proven that it's burden otherwise. You are doing your duty as Americans when you sign not guilty on that very step. Thank you.
Ms. Trencher, you have 8 minutes remaining.
Thank you, Your Honor. You know who else is a person? Officer Sikkim is a person.
No.
Officer Romine is a person. And they deserve respect enough that they can go home to their families at night.
Next, you'll tell me a lawyer is a person.
There is nothing in any prison policy that Mr. Engel is going to put in front of you, ladies and gentlemen, that says they have to step back and wait to get hurt. That they have to step back and wait to react to a defendant who is a threat to them. You're not going to find that. It's officer safety. They told you all about pre-aggression indicators. They told you about their training, and they reacted and did as they were trained to do so. Like it or not, law enforcement, be it corrections officers, be it the highway patrol, be it a police officer who pulls you over for speeding, they all have some amount of discretion in their jobs. An officer can pull you over, for instance, and give you a warning for speeding. An officer can pull you over and give you a ticket. That's called discretion. It's no different than the discretion that is held within the prison, the discretion between that Officer Sikkim told you about and Officer Romine. Okay? They are not there to make lives miserable. In fact, they were trying to cut the defendant a break because it's July and it's hot, and they were trying not to take his fan. But he wouldn't comply. You want to know why there was no contraband log? Because the search wasn't finished. The search had not concluded to then go to the next step of creating a contraband log because he didn't allow the search to finish.
So, okay. So they went to his cell after lights out because they were confident there was a shiv, some kind of weapon. Very dangerous. They had to go after 9 o'clock to find this shiv. And they even said on the video, it's gotta be here somewhere. Keep looking. And then this whole altercation happened. And because this whole altercation happened, they just said, screw it. We don't need to go continue checking the cell. We don't need to go look for that shiv. Screw it. How is that helping your case, sweetie? So what, all you have to do is fight with the guards to get out of your to distract them if somebody's cell is getting searched? I, I, that what they should have done is they should have gone back and finished the reports after. Hey, maybe I have higher expectations than I should, but I don't know.
It was interrupted by his acts of violence. They went to the hospital. They didn't create the contraband log. They were a little busy at the hospital. This whole use of force policy, Mr. Engel has pointed out time and time again that there has to be use your interpersonal skills to de-escalate a situation. The part that he keeps forgetting is the next part of that sentence, as long as it is safe to do so. Again, they are not required to sit around and try to have a long talk with the defendant. This isn't someone you're disagreeing with out in the open that you can sit down at Starbucks and have a cup of coffee and work out your differences. This is a prison. This is an environment by its very nature that is violent. You can't just wait around for a supervisor just because some inmate demands it. That is part of the discretion. The situation did not call for that. I know you don't want to hear any more about the pillows, but I'm going to say one more thing.
Oh, God. Well,
Legal or not legal.
okay, first of all, if you think the jury doesn't want to hear any more about a subject, I don't know if you should continue harping on it. Second of all, his face is just great. He's just enjoying this. What is she talking about?
Pillows, but I'm going to say one more thing.
I'm going to say one more thing, and he just smirks. He just knows, like you just said, the jury doesn't want to hear it. Why are you still talking about it?
Legal or not legal, Mr. Engel says that answer could have been easily known if Trooper Klons had confiscated them and so we could all examine them. Well, first of all, that's an administrative role. That officer or Investigator Chamberlain told you that's his role. Okay, it's not Trooper Klons' role to decide whether or not something is legal within the prison itself, as far as that kind of property goes. We could also get that answer another way. We could have gotten that answer if the defendant had followed the proper procedure and filled out the proper kite and paperwork to challenge what the officers took from his cell. And I think that Mr. Engel's description of the testimony given by Officer Sikkema and Officer Romine and saying that it was lies, I think that's disingenuous. Yeah, they filled out those reports. They filled out the use of force reports. But as you can tell from watching these videos multiple times, I mean, this is something that happened like that. Even trying to watch them without slowing them down, it's your head is kind of spinning, I would submit to you. They did not have the benefit when they filled out these reports immediately after this incident of having months and months to dissect the video and slow it down and go frame by frame to see exactly what happened. So yeah, there might be details left out. That's understandable. Because that's a lot of information to cram into one little report in such a little amount of time. This case, ladies and gentlemen, in spite of all the policies that have been thrown at you and the codes and the regulations, it really comes down to one thing. It comes down to the fact that the defendant threw a temper tantrum. He is a person who I think is evident, came through as evidence in his own testimony. He's an individual who's used to getting his own way. He was fine with discretion that other officers may have had in prior cell searches when he requested the white shirt, requested the supervisor, and that officer used that discretion to go ahead and call somebody down. He was fine with that amount of discretion. But they're not fine with the discretion that Officer Sycamore and Officer Romine used to not call somebody down. He's fine with the discretion that officers used in prior cell searches, maybe even the day before when they didn't take his unauthorized and altered fan. He's fine with that discretion. But he's not fine when they use their discretion to take the fan. When it doesn't go his way, he gets mad. It didn't go his way this time, and he got mad. He created the situation. He escalated the force. Officers used reasonable force to respond to the situation. They were not the one, he was not the one to end up in the hospital after. They were. Reasonable force, ladies and gentlemen. It's not complicated. They used reasonable force. Self-defense does not apply in this particular manner. Even if you think the force was not reasonable, self-defense, as I showed you in my first portion of my closing, doesn't apply. He escalated the force. It does not apply. He started the situation, created the situation. Self-defense does not apply. Thank you for your time and attention, ladies and gentlemen. We would ask, on behalf of the state of Ohio, of finding the guilty on all charges. Thank you.
So, ladies and gentlemen, I'm in my 20th year as a judge here in Warren County. And what I've learned in that time is that different people absorb information in different ways. It's time now for me to give you the instructions of law.
I'll
And
skip forward through the beginning parts. Maybe we can watch a little bit real quick.
it's been my experience guilty of either or both of these counts, you will continue your deliberations. And this is an act in which, in a natural and continuous to prove his character in order to show that he acted in conformity with that character on the day that this happened. A number of exhibits and the testimony related to them have been introduced. You may consider whether the exhibits are the same objects in the same condition or whether or not they accurately depict what they purport to be. You will determine what weight the exhibits should receive in light of all the evidence. It may be that not all of the exhibits that were referenced during the trial were admitted into evidence. You're not to draw any inferences by the fact that some of the evidence may not have been admitted. You will have with you in the jury room the recorded exhibits and a computer without internet access with which to play these recordings. You shall consider whether the recording is a true record of what transpired at the time it was taken. If you find that it is, then you will determine what weight, if any, the recording should receive in light of all the evidence. If you're unable to play the file on the computer and you wish to view it, please contact Ms. Kuroko. She can help you with any of the technical aspects. The defendant is charged in count 1 with felonious assault. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about July 23rd, 2024, in Warren County, Ohio, the defendant knowingly caused serious physical harm to Owen Sycamore. A person acts knowingly, regardless of purpose, when that person is aware the person's conduct will probably cause a certain result or be of a certain nature. A person has knowledge of circumstances when the person is aware that such circumstances probably exist. Because you cannot look into the mind of another, knowledge is determined from all the facts and circumstances in evidence. You will determine from these facts and circumstances whether there existed at the time in the mind of the defendant an awareness of the probability that the defendant knowingly caused serious physical harm to CO Sycamore. Cause is an essential element of the offense. Cause is an act which in the lost my place here, hold on. Cause, an essential element. Cause is an act in which, in a natural and continuous sequence, directly produces the serious physical harm and without which it would not have occurred. The defendant's responsibility is not limited to the immediate or most obvious result of the defendant's act. The defendant is also responsible for the natural and foreseeable results that follow in the ordinary course of events from the act. The state of Ohio not need prove that the defendant intended to cause the specific harm that resulted, but it must be established beyond a reasonable doubt that the harm that resulted was a natural and foreseeable result of his actions. Proof of motive is not required as to the issue of whether or not the defendant acted knowingly. Serious physical harm means any of the following. Number one, any physical harm that carries a substantial risk of death. Two, any physical harm that involves some permanent incapacity, whether partial or total, or that involves some temporary substantial incapacity. Three, any physical harm that involves some permanent disfigurement or that involves some temporary serious disfigurement. And four, any physical harm that involves acute pain of such duration as to result in substantial suffering or that involves any degree of prolonged or intractable pain. Physical harm means any injury or illness or other physiological impairment regardless of its gravity or duration. In counts 2 and 3, the defendant is charged with assault. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about July 23rd, 2024, and in Warren County, Ohio, the defendant knowingly caused or attempted to cause physical harm to the victim, a corrections officer in a state prison. Count 2 relates to CO Sycamore. Count 3 relates to CO Roma. The terms knowingly cause and physical harm have already been defined for you, and you will use those definitions for these counts as well. An attempt occurs when a person knowingly engages in conduct that, if successful, would result in physical harm. If you find the defendant is guilty of either or both of these counts, you will continue your deliberations and determine whether or not 3 additional elements have been proven beyond a reasonable doubt. 1, whether the assault took place in or on the grounds of a state correctional institution. 2, whether or not the victim of the offense is an employee of the Department of Rehabilitation and Corrections. And 3, whether or not the offense was committed by a person incarcerated in the state correctional institution. If you find the defendant not guilty on either of those counts, you do not need to make these additional findings. The defendant is charged in count 4 with strangulation. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about July the 23rd, 2024, and in Warren County, Ohio, the defendant knowingly created a substantial risk of serious physical harm to Casey Romine by strangulation or suffocation. The terms knowingly cause and serious physical harm have already been defined for you. You will use those definitions for this count as well.
How are you, Helen?
I'm sleepy, but apart from that, I'm okay.
Cool. We're just going to listen to a couple minutes more of jury instructions and then skip forward.
Yep.
Strangulation or suffocation means any act that impedes the normal breathing or circulation of the blood by applying pressure to the throat or neck or by covering the nose and the mouth. Substantial risk means a strong possibility as contrasted with a remote or even a significant possibility that a certain result may occur or that certain circumstances may exist. The defendant has raised the issue of self-defense. Generally, a person has the right to assert self-defense as an affirmative defense to charges such as these. However, because the defendant is an inmate in a state correctional facility, the rules are a little different, and the standard for establishing self-defense is heightened. Ohio law imposes upon a corrections officer a duty of reasonable care to provide for the health, care, and well-being of an inmate. A corrections officer is permitted to use reasonable force to control an inmate or to respond to resistance by that inmate. An inmate has no legal right to resist reasonable force. An inmate does have the right to resist and to act in self-defense to reasonably defend himself against excessive force. Force means the exertion or application of any physical compulsion or constraint. Reasonable force means force used in accordance with the following guidelines. 1. A corrections officer may use a small amount of force as may be necessary to restrain, guide, support, or direct an inmate, or to apply handcuffs, waist or leg restraints in connection with accepted procedures of transport or movement. 2. Amount of force. A corrections officer, considering the use of force, shall evaluate the need to use force based on the circumstances as known and perceived at the time it is considered. 3. A corrections officer may use force only to the extent deemed necessary to control the situation. The corrections officer shall increase or decrease the level of force as resistance increases or decreases. A corrections officer should attempt only to use that amount of force reasonably necessary under the circumstances to control the situation and shall attempt to minimize physical injury. And finally, 5, force or physical harm shall not be used as punishment. There are 6 general circumstances under which a corrections officer may use force against an inmate. 1, self-defense from a physical attack or threat of physical harm. 2, defense of another from physical attack or threat of physical attack. 3, when necessary to control or subdue an inmate who refuses to obey prison rules, regulations, or orders. 4, when necessary to stop an inmate from destroying property or engaging in a riot or other disturbance. 5, prevention of escape or apprehension of an escapee. Or 6, controlling or subduing an inmate in order to stop or to prevent self-inflicted harm. Excessive force means an application of force which is greater than reasonable force, either by the type of force employed or the extent to which such force is employed. If you find the defendant was subjected to reasonable force only, then you are not to consider self-defense. However, if the defendant was subjected to excessive force, you may consider self-defense. If you find the defendant was subjected to excessive force, the state of Ohio must prove the defendant did not act in self-defense by proving beyond a reasonable doubt at least one of the following elements. 1, the defendant was at fault in creating the situation, giving rise to the use of excessive force by the corrections officer. Or 2, the defendant did not have reasonable grounds to believe that he was in immediate danger of being subjected to excessive force. 3, the defendant did not have an honest belief, even if mistaken, that he was in immediate danger of being subjected to excessive force. Or 4, the defendant used unreasonable force. In deciding whether the state of Ohio has proved beyond a reasonable doubt that the defendant did not act in self-defense, you need not be unanimous as to which of the elements were proven, so long as each juror has concluded the state of Ohio has proven beyond a reasonable doubt at least one of them.
Okay. I'm going to go ahead and skip forward a little bit. Let's see the poll. So 52% think hung jury on some, verdict on others. Well, let's see.
How many charges are there?
Good question. I believe I should. Damn it. That is jail history pulled up. Sorry, guys. I have way too many tabs open. Okay, so 4 charges total. Felonious assault, 2 assault, and then a 4th strangulation. Okay.
Of being
So just kind of an empty courtroom. It went for hours. It went all yesterday. They were out. We did not
Yeah.
get a verdict yesterday. The jury wanted to deliberate, and they let him deliberate. The attorneys were still there quite late.
Hey, Donald. Aren't you cute? Subscribe to my channel, and I have a PayPal as well.
So where the hell were they? Near the end of the day, they were just kind of like perusing. Oh yeah, that's when they came back yesterday.
No hell. Stop it.
I just want to play the end of the day yesterday. This was like 9 o'clock local time, 9 p.m.
My kid is also super smart.
Yeah.
And she'll tell you that too.
Okay, so this
Thank you, Donald.
okay, no, so they really hadn't heard anything. This is when they asked a jury question around like 8 o'clock local time.
All right, we are back on the, you can be seated. We're back on the record in Mr. Thomas's case. It is now 8:32. We've received a question from the jury. Were any medical records submitted for CO Romine?
And so they're talking about the strangulation.
Right.
the
Oh,
jury
that's right. Because they wanted to know. They wanted to know whether there was proof of the strangulation at the
Yeah.
medical records, which there should have been.
But she didn't submit them.
Duh.
Well, and he never went to the doctor for it either. Or like
What?
either. Well, he said he had like a little twinge, but that he's never really seen a doctor about it.
Oh, nasty strangulation then,
Yeah.
right? Okay, we shouldn't have even heard about strangulation if he didn't have to even see an ME about it.
Yeah.
That's
He,
crap.
he may have been checked out. Or you went to medical, so yeah, that's about it.
Okay, you're gonna charge someone for strangling you? Then there should be a medical report about it at the
My-
very least.
Guess is the jury was divided, and one side was trying to prove to the other side, and they just needed that.
They shouldn't have to even argue about it. There should have
Yeah.
been at least a report. I'm surprised there wasn't a someone there to testify to what the injuries were. Like a medical examiner.
Well, the officer testified.
The officer himself testified. Well, he not an expert.
Well, and he just was like, "Yeah, I was scared. I was, blah blah blah."
Yeah, good for
But-
him. Well, that's great. But yeah, like usually there's whoever the first responder was, or they took you to the medical unit or hospital or whatever. Someone testifies.
Yeah.
But no, it's just shit.
Wait, this cut off the last.
He had bruises on his neck. He said, okay, so he said that. Was there
Faint
photos of
bruises.
them?
Yeah, they did show photos. It wasn't very.
Okay.
I didn't think it was very impressive, but yeah, apparently they didn't.
Bruce Kitten.
Okay, so I did not save the last like half hour of the day.
Medical
That's
ex-
fine.
Oh, we say medical examiner sometimes. But what do you mean? Like, so medical examiners, you can only call them
they
medical examiners if
They
they're
have
dead.
all the exhibits.
Do you want me to tell them no?
They examine
Or do you want me to
medically.
tell them you have all the exhibits that you need?
Tell them you have all the exhibits that you need.
I worry about that word need,
It's just
Your Honor. I wonder if we'd better say.
She's from
You
the
have all the
south.
exhibits that were admitted?
you
I
have
am
all
from the south.
That's what it is.
Okay, I will answer it. You have all the exhibits that were admitted.
Deep south.
All right. And Mr. Engel, do you continue what Mr. Thomas brought over if there's another question or not?
No, I spoke with him and.
Very
if there's
deep
something like
south.
this, we're okay with waiving his presence.
Okay, all right. I'll send that in. We're in recess.
Okay, so they go home. They tell the jury. The jury says we can't. We're hopelessly deadlocked. So
Really?
they come back last night around 9, and the judge is like, "Okay, go home. Come back tomorrow," which I'm sure pissed them off.
Yeah, I would have thought the reason they're staying so late is because they hope to get it done that day.
Yeah, and they were trying to do their best.
Yeah.
So they had to come back this morning. Judge gave them the Allen charge.
Mm.
Oh, yeah, Scott. Thank you, Scott. It's a good idea. Actually, yeah, Scott saved the video, so I can just use that. And then we'll go to today.
Correct, Johnny. I'm doing my best. Do you believe it yet? I'm only partially convinced myself.
All right, we are back on the record in Mr. Thomas's case. It is now 9:29. The court has
9:29.
received a note from the jurors indicating that they cannot reach a unanimous verdict. You can be seated.
Thank you, Scott.
Given the lateness of the hour, I think rather than give them the dynamite charge tonight, I'm going to bring them back tomorrow. So we're going to bring them back 8:45 tomorrow, and then tomorrow morning I will give them a dynamite charge, put them back to work.
I think that makes sense.
All right, Ms. Kroko, go to the jury, please.
Boom.
You want us present for that?
Yes. Does that work a hardship on anybody?
Chip.
Defendant has to check his schedule.
It's a right pain in the ass. I want a white shirt.
I should start demanding a white shirt.
Yeah. I have a mental health caseload.
You may be seated. Long day, ladies and gentlemen. On behalf of myself and the parties, I do want to thank you for the hard work that you are doing in the case. I did receive a note from you indicating that you may not be able to reach a unanimous verdict on one or more of the charges. I know this is a new and difficult task for you. The process of discussion and deliberation is necessarily one that requires consideration and patience. And the secrecy that surrounds your deliberations and your efforts prevents others, including the court, from knowing when your efforts will result in a verdict. Because you have been deliberating for the better part of the day, I'm going to send you home for the night, and I'm going to have you return tomorrow at 8:45. At that time, we will resume deliberations, and we will discuss your next step. So we are in recess. Remember all the things that I have previously told you. Do not discuss the case with any of your family members or any friends. Don't do any research on the case.
Damn, but I posted to Facebook.
Don't do any Google searches, any independent research.
And say Dolly.
What I would suggest to you, instead of what you're probably going to do, is that you go home and you forget about this case until tomorrow morning. Don't think about your position. Don't think about the positions of the jurors that may disagree with you. Don't think about anything like that. Just unplug your brain to the extent that you can, so that when we come in tomorrow, we will sort of have a fresh perspective and not just necessarily pick up where we left off, but we will start again with sort of a new perspective. So we will see everybody tomorrow morning at 8:45. Ms. Kroko, you can take the jury out. All right, anything additional from the state?
No, Your Honor.
Anything additional from the defense?
No, Your Honor.
All right, generally, the charge that I give them is a modified Howard charge, which basically says that there might be a time where further deliberations serve no useful purpose, and then we will send them a note in that says we want to keep going, or deliberations serve no useful purpose. So usually I send that note in after about 15 minutes, but tomorrow morning I'll probably give them the dynamite charge, put them to work, and then wait maybe an hour and send them that note then. Okay? All right, we'll see everybody tomorrow morning.
Thanks, Your Honor.
I mean, do you want me to just go ahead and give them the charge in the morning without you being here? I mean, if everybody waives their presence, I'll do that. It doesn't matter to me.
It doesn't matter. I mean, I can be here. No big deal.
I have to be here tomorrow morning for Judge Peeler, so just a little bit early. That's okay.
Okay. All right. Come here first. Don't get stuck in Judge Peeler's courtroom. All right. That's all.
Not putting that on the record.
Okay. So I don't have the beginning of today when the jury came and he did the dynamite charge because of the stupid court. But we have what happened next. Okay.
We are on the record for the purpose of an early termination hearing. Mr. View, anything from the state?
Wrong one.
Mike.
The parties here are just lurking in the background. Waiting for them to just finish up.
This was somebody writes a check to themselves and tries to cash.
And this was like it was like 9.5, almost 10 hours, I believe, of deliberation.
What?
To get to
10
this point.
hours?
10
There
hours,
must
yep.
have been a complete asshole on the jury.
Well, I do know. Well, we'll discuss that after.
It on a company account. No money was no issues. See? Yes. That's why I see.
If I were on a jury, I'd be that asshole.
Oh, yeah.
Oh, yeah. I'd so be that asshole. I'd be calling them all a bunch of snowflakes and softcocks.
Oh, yeah. My dad made another juror cry once.
Oh, awesome. I'd be like,
Oh, what a softcock.
She was the holdout.
yeah. But no, I try not to get weirded out in jury selection. I'd be so sweet. I love that.
CR 42241. It is 11:14 a.m. And we have received a note from the jury that indicates that they have a verdict, but they do not have a verdict on counts 2 and 3.
Ooh.
So everybody can be seated. When we bring in the jury for the reading of the verdict, everybody is to.
So
Piss off.
So we don't have a full verdict, but we have a verdict on some of the charges.
Look, if you want me to insult you, we have to go over to my channel and you got to pay. David set the starting price at 20 US, so.
Yes.
But I'll insult you. No worries.
Remain seated. That includes you folks in the gallery. Everybody just remain seated. All right, you can get the jury, please.
By Franz, no, this was earlier today. So, guilty or not guilty?
Let's go.
Oh yeah, that's RA's court reporter there, next to Mama.
Of course it is.
Maybe seated.
I think
Good morning, almost afternoon, ladies and gentlemen.
she was probably concerned where the hooch went.
It's my understanding that you have reached a verdict on some of the counts, but not all of the counts. All right. So first of all, was everybody able to follow my instructions and admonitions while we were deliberating? Were you all able to keep from any outside influences while you were doing your deliberation process? All right. So Ms. Grimes, you're our foreperson, right? If you could please hand the verdict form
Grimes.
to Ms. Kuroko in advance of the reading of the verdict. I want to thank you all for your service in what has been a very long and difficult process. All right. With regard to count one, verdict form says, we, the jury in the above captioned case, find the defendant Thornton Thomas not guilty on the charge of felonious assault. And it appears that there are 12 signatures attached.
Felonious assault, the biggest
Count
one.
four, we, the jury in the above captioned case, find the defendant Thornton Thomas not guilty of the charge of strangulation. And then we do have the note from the jury indicating that we did not come to a consensus on counts 2 and 3.
The
So
simple
those
assault.
verdict forms are both.
The simple assaults were the ones they couldn't come to a consensus on. The felony assault and the strangulation, they said not guilty.
Okay, that is Jose Baez Jr. right there.
Yeah.
That's the Ohio version.
Yeah.
What a dude. What a dude.
I mean,
I
that's
like him.
basically jury nullification there.
That's brilliant. He is a really good attorney. Like, I really liked
Yeah.
his closing argument a lot. Like, he took a little bit of time to get to the specifics, but I love the way that he talked about how the community needs to look out for misconduct by the government and how we just shouldn't take everything that they say for granted. I was just like, yeah, preach, brother. Go.
So, supposedly we did from RA's insider, she found the breakdown for count 2 and count 3 that were hung. Count 2 for Sycamore, the busted tooth, 5 were not guilty, 7 were guilty. So then count 3, the officer who was strangled, there was 1 not guilty, 11 guilty.
For which, sorry?
The officer who was strangled, just the assault charge.
Oh, okay. So, wow, that's a big switch.
Yeah, so one of them was like 5 not guilty, 7 guilty, and then the other one was 1 not guilty, 11 guilty.
Yet they came to unanimous decision, not guilty on the other 2.
Yep. Right? Maybe because no medical report proven it.
Okay.
Yeah, 1 juror saved his ass.
It sounds like this one juror probably had a fair bit of influence, like
I'm thinking.
that, and that'd be why it took so long.
I'm guessing there was at least, I'm guessing it was a holdout who was actually because sometimes there's holdouts who are weak personalities and give in, but this was, one of the stronger forces on the jury who was the holdout.
Yeah.
And that's
Yeah.
a problem.
And
So yeah,
probably
they can still retry him. Well, we'll play it.
Blank.
Yep.
Ms. Grimes, are those the verdicts of the jury?
Yes, there.
Does either side want to have the jury polled?
No, Your Honor.
No, Your Honor.
All right, ladies and gentlemen, this now releases you from your service, almost. I have a visit from my court administrator who is in the process of doing a rather comprehensive study on juror trauma. So she wants to talk to you a little bit about your experience here. Won't take very long. I'll probably come back and talk to you as well. And then we'll get you on your way. Thank you again for your hard work in the case. Mr. Groko, you can take the jury out. Everybody, you can remain seated.
He is happy. His mom is
Look at
happy.
him. What a
Oh, his
dude.
mom is happy.
Oh, she's not going to throw up now, is she? Look at
No.
her smile.
Oh,
She's so
that wasn't me.
Do you want to
Tell your son to stop beating
talk to the
people up.
jurors?
Wait. Who farted?
Do you want
Whoa. Is that the defendant?
to
Someone
talk to
farted.
the jurors if they are interested in talking to you?
If they want, really the only thing I'm interested in is the count, because that's gonna
Yes,
count
boy,
Okay.
boy,
the division
talk about it
if
now.
they don't want to talk to us.
Okay.
Yeah, I always like to talk to them just to know where.
Ms. Burnside might wear them out on her juror trauma stuff. I don't know
Kinda what I'm
about
thinking.
that, but
But if you could find that, that will help me in the decision that has to be made.
all right. Why don't we set this for a status
Aw.
conference in about
We need to make a
3
decision.
weeks? Then we should know, right, as to
Oh,
whether
for
or
sure. Yeah.
not.
You really
And
suck,
I don't
lady.
know. I don't know that it makes sense to transport Mr. Thomas for that. The state's either going to,
We're either going to set a new trial date or
I assume Mr. Engel is going to file a motion to dismiss to prevent me from having another trial in the case, but that's all sort of caught up in the process. But that doesn't really require Mr. Thomas to be transported, right?
No, I'm wondering, Judge, if, I don't know what the procedure would be, but if there's a decision that could be made quicker by the prosecutor's office, we could even keep him here. We could keep
They don't
here
want him in the jail any longer than he has to be. So,
Oh, and one thing I did see when I was getting this set up, right after the jury went out yesterday, his
Mhm.
mom came over and the defense attorney shook his mom's hand and they let his mom hug him,
Really?
which was really sweet. It very surprised me. Yes, Louise, we just played the verdict. So you'll want to go back like 15 minutes. So, but yeah, it usually they don't allow you to talk to in custody defendants.
So, hang on. Are they defense attorney's trying to talk the court into pushing the prosecution to make a decision right now?
Probably, but she doesn't really have the authority for that.
No, but I think he's trying to get her to get on the phone
Yeah. Oh,
to
yeah.
her bosses now before everyone leaves for the day and get them to go, okay, no, we'll drop it.
Yeah.
Ha. Good on him. I
we're
love
going to
this
ride him out
guy.
as soon as possible.
Yeah, then I would say we waive his presence and we can, for the status conference.
Okay. Mr. Thomas, I know you need to talk to your attorney about this, but there's a couple of things that need to happen after today's hearing. You've been found not guilty on the 2 charges, the felonious assault and the strangulation, but we have no verdict on the assault on the corrections officers. So a hung jury means that under certain circumstances, the state of Ohio can try you again only on those counts. Can't try you on the felonious assault. Can't try you on the strangulation. But we could have another trial in theory on the issue of the assault charges only. Mr. Engel, I assume he's going to be filing some motions that prevent the state from trying you again. The state may not even want to try you again. I don't know. None of those decisions really involve you. So my thought is that we'll set a status conference without you here, so we don't have to bring you down here again, and then we'll just let you know how things come out.
Yes,
Obviously, if there's going to be another trial, you'll be here for that.
Yes, sir.
Okay?
Yes, sir.
If it's all right with the court would waive any deadlines I have. I don't know what deadlines I might have, but until we hear from the prosecutor's office what they intend to do, I don't want to file any motions if it's it's not necessary.
We should know in a couple of days, right?
I can't, I'm not the person who makes that decision, so I will set the wheels in motion and let you know as soon as
Wheels in
possible.
motion.
All right, let's plan
Yeah,
on
okay.
touching base
In the
via
fullness of
email
time.
on Monday. I will generate
Sounds good.
the email and everybody will be on it. I'll send an email to everybody that says, hey, where are we? And
This is
then
bullshit.
I'll stay the time for filing of motions. I don't know what the deadlines are.
Fuck's sake. This is like
Yeah.
Sarah Boone having to send a fucking letter via snail mail to the court from friggin' down the road.
Yeah.
Right? This is crap. Nidawal just said that it's literally across the hall.
Yeah, she could go ask her boss.
She
Or,
could just go ask her boss. Everyone's there.
Yeah.
Everybody is freaking there. Why do we have to go through all this bureaucracy in order to have a decision as to whether or not these charges are going to be dropped? Because it's pretty obvious that these charges are going to be dropped. They should be. If they're not going to, if it's not going to be able to be dropped, then, I mean, if they're not sure, then fine, then go through the however long it's going to take. But, like, really? No, it isn't, you think? Could he be moved down from max level now?
I
I
was
don't
wondering
know.
that.
I don't
Probably
know.
not, but
It's probably Kendall's decision, who is definitely in his office. It doesn't seem like it should need this level of fucking around,
yeah,
right?
she's just butthurt.
Yeah, she's butthurt. Yeah.
Well, at least he has a chance right now to get out. So,
Has he?
I mean, he'll be out in 39.
39.
Yeah. That's when he's eligible for parole.
Okay, let's just be real here. This is not going to be the last time he gets in trouble.
Probably not.
Let's just be.
Well-
He's not going to suddenly reform. But fine.
Yeah.
They wouldn't let his daughter hug him.
Oh, is that his daughter in court?
That was his mum.
I did see him hug the woman that was there for him right after the jury left, briefly.
Mm.
But yeah, this was a really, really interesting case.
So is that it?
Yeah, that's it.
Okay.
I know, right?
I like that lawyer. Let's get him on.
Wonder if he'd want to. Might as well could reach out.
Yeah.
Yeah, that was just great. Great job.
He was really good. In fact,
And
let's follow him around. Like if we see he's got something on.
He was on he did one other trial, and I think he
Yeah.
lost that one. But I didn't see that one because I was doing the tar jousting coverage.
Tar jousting. Well, we have
Yeah.
okay. Oh, speaking of tar jousting,
Yes.
there's more coming, right?
Yes, there is. I don't know if it's still going in November. It said it was delayed again, or it said it was potentially delayed. So it may not start in November, but I'm really hoping it does.
Okay, can you tell people what you're talking about? Because
Okay,
it sounds like we're just having a conversation between ourselves.
good point. Look at you making
Yeah.
my stream better. Last week I covered the Ted Gerbel versus, let me get their names because it
Goebel versus
Charles Gerbel versus Timothy Hopkins.
That's right.
Timothy Hopkins
Wheelchair
had,
man.
yeah, he lost his leg after a knee. Thank you, Scott. I'm bad.
Thank you.
After a knee transplant, bacteria got in there, infected, and he had to have his leg amputated. Yeah. So he's very rich. Chuck Gerbil. Oh, that's hard. Yeah.
Yeah, that one.
And the Gerbils live next door, and
Mhm.
there was property dispute, and Timothy Hopkins did not like that Chuck Gerbil had a restriction on his property on where he could build a garage. Timothy did not know he had that restriction, but he did because the builder screwed at them both over.
And there was a purple Lamborghini involved, and
And Timothy Hopkins is the kind of person to hold a slight grudge. So he was very petty and did a lot of things to piss off Chuck and low T
Chuck and his wife have a lot of bedroom problems,
and
and we found out about that too.
yeah, she has low T.
She has low testosterone,
And
which we didn't know was a
he's
thing.
he's a limp noodle.
He's a soft cock.
flaccid. He's soft.
Yeah. He's
He's
soft, yeah.
limp.
But he might be just slightly more turgid
Yes.
since they won how many $1 million?
Oh,
4.5?
yeah, a lot, several million
Yeah,
on that first case.
which is infuriating.
Very infuriating.
But
Because
there's more.
yes, there is another trial coming up next month. I believe this one focuses on like the property dispute and all that. So the first trial was just about the harassment and the bedroom problems and the poor emotional distress.
Yes. Yes. And a flaccid man. Indeed. And
I
they
mean,
don't mind airing all of that stuff in order to get their $4.5 million. And you know what? I think I'd make that shit up.
I know.
Why not?
I mean, if it happens again, I won't cover the whole thing, but I will cover the highlights.
No. Yeah, Dali's got that problem too.
Well, no, not anymore that I quit drinking.
No, you're the only one on the bed.
Oh, that problem, yeah. Okay.
Yeah.
No, I got my cat.
Well, that's not a solution
Good point.
that you want to talk about.
Yeah, okay. That's awkward.
Mm.
Wah, wah. Shit. God damn it.
Oh, he's gone.
Ah. Yeah, I'll have a less humiliating picture up there now.
No.
So yeah, we'll have another trial next week. Not sure which one yet, but I'll find something good, I'm sure.
Yeah.
And I'll keep an eye open. Maybe tomorrow Peeler might have one. Ooh, excuse me. I'm not sure if it's going to go forward yet. But yes, tomorrow at 10 a.m. we will be back for courtroom roulette. And what do you have coming up, Hella?
I'm thinking I'm going to start a new thing. So, and I want people's ideas on it. So it occurred to me when I was talking to somebody the other day that there's been like a bunch of trials go past that we might have missed, and there might have been some defendants who got up on the stand and had some really good testimony. So I was thinking about just playing back defendant testimony that we might not have seen, or maybe some of us have seen it and some of us haven't.
It's a good idea.
Yeah. And the first one I thought of doing was Zachary Hughes. I don't know if you guys have seen Zachary Hughes's, but
No.
his was amazing. I think you
Oh,
did
the rose
actually
petal
see
guy?
some of it. Yeah, the rose petal guy.
Okay.
Yeah.
I didn't see it.
The reason I want to play his is because it's kind of a little bit similar to the case of Aaron Spencer in Arkansas, in that this guy thought his reasoning was that the girl was being abused,
Mm.
right? And he
One
was
of
going
those.
to save her. Yeah. And he went in and just like flat out murdered somebody.
Mm.
It wasn't self-defense though. It's a bit different. It wasn't self-defense. But his take on it was like, I have to kill this guy because he is abusing this girl. Right? I must. And he went in there and just, it was so premeditated though, is a bit different. But as far as he's concerned, he's a hero, and his dad even thought he was a hero as well. And it was, yeah, and it's just the most intense testimony. And it just, like, the delusion in him that he really thought it was the right thing to do.
Yeah.
But as far as he was concerned, he had to do it. He had no choice.
Yeah.
You know. So yeah, if you haven't seen it, you should probably tune in, because it was pretty wild. No one thought that the trial was going to be any good until he got up there. So yeah,
was that-
and I want like other people's suggestions on other things to watch as well.
Yeah, definitely.
Yeah.
Yeah, that's coming up. I guess that is tomorrow. That older guy didn't clean up his property multiple times. He was told by the judge, and he was sentenced to 5 days in jail. And he's going to be back, and we'll find out if he's cleaned up his property yet, or if he's going back for more time. That was a good one. So yeah, that's awesome. We'll keep an eye out for that, Hella. Thanks, guys, for being here. And I shall see you guys tomorrow. Toodles.